Good afternoon, everyone. I'm Carlton Mace with Quadro Counsel. For those of you that have been with us before, welcome back. For newcomers, we welcome you for the first in our many webinar series presentations. Today's webinar will focus on dividing federal employees' retirement benefits, and the topics to be covered are the federal employee retirement defined benefit plans and the federal employee thrift savings plans. Some of the issues that we'll cover in addition will be what information is needed, what plans are involved, issues surrounding active employees versus retired employees, and the best way to divide federal employee plans and important language to have in your judgment language to preserve survivor benefits as well as in the domestic relation order. Our expert speakers today are Lorena Duffy and Louise Nixon. Lorena is a nationally recognized Quadro expert with a diverse background in Quadros and family law. Lorena is a recurrent family law court appointed expert on Quadros and frequent speaker on Quadros. She has practiced law since 2006, including as attorney for the Legal Aid Foundation of Los Angeles. Lorena is the president of the Latina Lawyers Bar Association, which services include providing Latinas with a community of support together with specific resources and tools to allow them to achieve their greatest potential, and provides law school scholarships. She is fluent in Spanish. Lorena practices law with Quadro Benefits Law Group and is a member of the Quadrones, a national study group comprised of Quadro attorneys and pension valuation experts. Louise is also a nationally recognized Quadro expert. Since 1994, she has practiced law specializing in retirement benefit divisions and Quadros. Louise is also a recurrent family law court appointed expert on Quadros and speaker on the subject. She has been quoted for her expertise in the Bloomberg Report, New York Times, and Wall Street Journal. She was awarded the Pro Bono Attorney of the Year by the Harriet Buhai Center for Family Law, a nonprofit which provides free legal services for low-income families in turmoil, and she is currently serving on their board. Louise continues to practice law with Quadro Benefits Law Group and is also a member of the Quadrones. Please know your microphones are turned off, and if anyone has a question during the presentation, use the Q&A function to post your question and not the chat function. We will address all questions. Lorena and Louise, it's yours to take it away.
Thank you, Carlton. I'm going to start. Good to have everybody join us today. Thank you very much. For those of you that don't know, Quadro Counsel is a legal support services company, and the experts involved with it include Lorena and myself, we're attorneys, and John Madden and Matt Schwartz, who are pension valuation experts and also pension experts. So we started this company and we are very proud of it. And the whole point of it is to provide access to information that is needed to divorce professionals, as well as doing Quadros for the individuals. So a little bit more of that, because we'll show you part of the platform in this PowerPoint. Also, just during the intro, I'll just take a moment to let everybody know that doesn't know about the two nonprofits that Lorena is involved with and that I'm involved with. Lorena actually was on the board for the Harriet Buhai Center for Family Law, which is an awesome legal services company, and we're a law firm, and they take the cases that basically are the last rung, where there's nobody else that could take it, and these people would otherwise not have access to justice. So it's a really important nonprofit law firm, and I encourage anybody who wants to know more about it to contact me or contact Buhai if they want to get involved, if they want to volunteer. We're doing really well on Zoom and still being able to service clients during the pandemic. So I just wanted to throw that out there. And then Loretta can tell you a little bit more, but on her nonprofit, in which she's president of the Latina Lawyers Association, it's such an important organization to support the Latina community. I don't know, she probably has more to say about it, what she can do when she does. Do you want to say something about it while we take a moment to talk about her?
Sure, just want to read it myself. We're the nation's only Latina Lawyer Bar Association, and our main focus is to support Latina attorneys at all levels in their career. And one of our major goals is to raise funds to provide scholarships to law students and also recent graduates taking the California State Bar.
So, okay, so just a little, say a little about nonprofits. I wish I could see people's faces. I always say that, but let's get started on federal employee plans, which I think a lot of people are scared of, which surprisingly, they're relatively easy to divide once you understand the issues. But the most important thing I can say about, and I'm going to say it many times during this talk, is if you get especially if you represent the out spouse on a federal plan, to file everything concurrently, because you can't, to protect your client, you have to serve the domestic relations order and the divorce judgment at the same time. And if there's a gap in there between the time the divorce judgment's filed and down the road when the quadro is done, there could be problems if in the event there's been a divorce, a retirement or death. So government plans, they're not governed by ERISA. That's a misnomer. People think that. They have their own rules that they follow, federal law, and they offer defined benefit plans and defined contribution plans. Quick recap, because we don't know the audience and what they know and don't know, but defined benefit plans are generally monthly plans that are valued at date of retirement by the member, by the participant, and there's a monthly check that is sent, paid monthly for the rest of the participant's life. And if it's allowed, and this plan will allow, we'll dive into survivor benefits for a former spouse's life or a spouse's life if they're still married. Defined contribution plans for public plans are also, they're like 401k. So think about it that way. For the government plan, that's a defined contribution plan offered to federal employees. That's the thrift savings plan. And I would say that we get calls, and Lorena can back me up on this, that but one of the two plans is missing from the judgment, or they're not aware that there's a thrift savings plan, or they think that the thrift savings plan is the only plan because they have a statement for that, but they don't have any information on the federal defined benefit plans, which are the $1 million asset. So anyway, so that's just a bit on that. These are the terms we use. Oh, and also I forgot, John Madden, probably some of you are like, where's John Madden? Because we advertised that he would be on here, and we really want him to be on here, but he had his whole power was shut off, and so he actually was all set to be part of this talk, but couldn't make it because he has no power. So so we will miss him, and he'll be hopefully doing the next talk with us. So there's just a term of art. A domestic relations order is technically, it's not a qualified domestic relations order is the term that's used to define a private plan. A domestic relations order is any judgment, decree, or court order. But I'm just going to refer to everything generically as a quadro. But just technically what we're doing for a public plan is a domestic relations order, not a qualified domestic relations order. So hold on the account. We get this question a lot for federal plans. There is no hold that is placed on a federal plan until they receive a domestic relations order with a divorce judgment that can be implemented. And they do not pre-approve. A lot of plans, private plans will pre-approve a quadro, but federal employee plans will not pre-approve. So joinders, though, they'll throw them away. It doesn't work. Notice of adverse interest served on a federal plan, a federal entity, they will not know what to do with them. They will not do anything with them. So we're going to talk first about the federal defined benefit plans. And I'm going to handle that. And then Lorena's going to talk about the thrift savings plans. But Lorena, please interject when you have.
Well, Louise, I did want to say, this
Yeah.
is, and you said this at the top of the hour, how important it is to, when you're preparing the judgment, to do the orders, especially for plans like this, where the joinder, the notice of adverse interest has absolutely no impact. If someone's close to retirement, or if you do the judgment and you tell your client, go get the quadro, get the draw done, and it's you're not sure if it's done. It's so important to do it together to protect your client, because again, there's consequences when or sometimes there's this preconceived notion that you have to wait until someone retires to do the draw, to do the quadro. Again, best practice, do it with a judgment to protect your client and protect yourself.
Right. So there are two plans that are offered to federal employees, two defined benefit plans. One is the Civil Service Retirement System, which is the first plan that was instituted by the federal government. And then around 1989, they switched plans to the federal retirement system first. So you're going to hear these people that come to you say, I'm in FERS or I'm in CSRS. If they're older, they may be in CSRS if they've been working for a long time. It's a slightly better payout, CSRS. If you mess up, and with our quadros, we actually name them both because we'll be told that the member's in one and he's actually in the other, or she's actually in the other. So it doesn't, it's good to know which one the member's in. Our orders protect against that. If you aren't sure because you're dealing with the out spouse and the other person's perhaps not cooperating. But I'll go into, really the main differences as we go further in this talk. The actual order that's generated is the domestic relations order. To do the division is called a court order acceptable for processing. The acronym for that is a COAP, C-O-A-P. And I'll go into the division of the plan by the time rule in a moment. So what discovery is needed for a federal defined benefit plan? I would say generally, in almost 9 out of 10 cases, or maybe even 9.5 out of 10 cases, all you need to know is that the employee is retired. That is where the line is drawn. That's where the impact can be on survivor benefits for the ex-spouse. If you come in after the fact, after a judgment's already done, if you can get the first order dividing the pension, it's almost in all cases the divorce judgment, then that's important to have, because what it states in there, if the employee is retired, can impact whether a survivor benefit can be awarded to the former spouse. The division for a federal employee plan is the time rule formula, which I think most of you are familiar with probably. There is 50% of a marital fraction. This is a formula that's used for defined benefit plans in almost every state across the country. And just generally, it's the number of months of service performed during the marriage over the total number of months of employee service through retirement. It just covers the time that the member is employed. It's done based on service credits, but generally that's the fraction that's used. And that's written, that fraction is actually written in the domestic relations order. And the Office of Personnel Management, OPM, which I'll tell you a little bit more about later, they are the ones that administer that and come up with what the percentage is based on the time rule formula that is written in the co-op, in the domestic relations order. When can the former spouse start benefits? When the member retires. So that's some plans, a lot of private plans, you don't have to wait for the member to retire. But as we go deeper into sort of the survivor benefit issue, you'll see that even if the member is not retired, you want to get the DRO, the domestic relations order, done to protect for survivor benefits in the event the employee dies before retirement. Otherwise, there'll be no payout to the former spouse. So let's talk about death. If the employee dies before retirement and is not married. So these are generally how, I'm going to say, you know, none of these plans that we deal with are perfect. The divisions are never going to be perfect. That's not possible to achieve. And the courts have come up through the years, and all the different courts, with what is most commonly used, so what we're going to talk about right now are what most people agree to if it hasn't been litigated, or if it has been litigated, what would be the outcome in terms of the award based on community property law. But you're dancing with state law and federal law, and we have to follow the rules of the plan, which are governed by federal law, by the law that governs these federal employee plans. And it doesn't fit perfectly with the California law and what the X is supposed to get. So we just do our best to get as close as possible. So with the active employee, if the employee dies before retirement and isn't married, there's no payment that's being made monthly to protect for the survivor benefit, which for OPM is for federal employees is called the former spouse survivor annuity. So what we do generally to capture funds that would otherwise just go back to the plan, nobody gets them. The participant can't leave a survivor benefit to the next door neighbor or to the kids or whatever for a lifetime benefit. It can only go to a spouse or former spouse. So if employees are married before retirement, what we generally do is just award in the order the entire former spouse survivor annuity to the former spouse, because it won't go to anybody else. And what that means is if the employee was in FERS, the former spouse would get 50% of what the monthly benefit would have been if the employee had retired on the date of death. And if he was in CSRS, the former spouse would get 55%. They get a little bit more with CSRS. That's really the main difference between the two and the cost of the survivor annuity. If the employee dies before retirement and is remarried at date of death, we, in the domestic relations orders that we generate, the most common option for, this is an active employee, is to award to the former spouse a survivor benefit equal to the same amount the former spouse would have received if the employee had lived. So I think that most people agree with that. There are a few issues that could come up on the front, but we're not going to dive deeper into those issues. So this is just, I'm going over what the most common option is for an active employee. And then if the employee,
Louise,
yeah,
we have a question. I don't know if it's,
yeah.
how do you handle
Yeah.
temporary orders for division with a status only dissolution?
Good question, because for federal employees, I would recommend completing the FL 347 form and just do the domestic relations order for a federal employee. Just because you're basically your award is you're doing an award. If you're going to divide it, then just do it, because otherwise, after divorce, after their status is ended, you won't. Your ex, if you represent the out spouse, that out spouse is not protected until the actual domestic relations order is done. If you're planning on doing some sort of an offset, I don't know. I'd still maybe would do it and then negotiate an offset and then vacate that order at a later time, because it may be a year or two before you get all that worked out on the property issues. Yeah. So you like that? Okay. Thanks, Catherine. Yeah. So that's what I recommend really in a bifurcation. And I think next year we're going to do a talk just on bifurcations. I'm so funny that you asked that question because I was on the phone with a family law attorney talking about it today. But I think for any bifurcation that you're going to divide that plan, the FL for in California, I know there's some out-of-state people on this, but whatever form you use, I would go ahead and do the quadro, because then that part is done in your case, and the X is protected, and you can move forward. And also just know, and you may have to tell the court this, that for bifurcation, you can't join these plans because they don't accept joinders. So sometimes that comes up too. So if the employee dies after retirement, now we're just talking about doing the co-op, doing the order while the member is still active, still an active employee. But if after the order's done, member retires, you still you have to put in a specific award of what the former spouse would get in the event of death. And we would generally default to the same award former spouse would get as if member had retired on the date of death. So that whatever amount the non-member is receiving while the employee is retired, that will stay the same. It won't be decreased. So if the employee retires and then divorces, so that's another fact pattern, and it really depends on what was elected at retirement by the employee. So if there was no survivor benefit elected at retirement, which would require the member, and if the member is married, that spouse signing a waiver to release and not have a survivor benefit payable. So there is some affirmative action that the spouse needs to take, and this is presumably the spouse that will be divorced later. But if, so just so you know, the default and the requirement is to provide for a federal employee to provide for survivor benefit. So if they elect that they don't want it because they'll get a little bit more money for the life of the member, and then when the member dies, it goes away, then there's no survivor benefit that's payable to a former spouse. There's nothing you can do about it. If it was elected, the former spouse and the former spouse was named as the beneficiary, because sometimes we get the calls and the divorce was many years ago and the co-op was never done. The participant has since remarried and then retires. So you have to make sure that the former spouse was the named beneficiary, that the retirement occurred during the marriage and then there was a subsequent divorce. Then what we generally do is award the survivor benefit, whatever was elected, to the former spouse. There are other options, but we'll get into the cost of the survivor benefit and the allocation of costs and what most people agree to, depending on their facts. So like I said before, there's no perfect solution, but what we have come up with, and I've consulted with actuaries about it, just actuarially what would be the most fair, not perfect, in the Division of Federal Employee Plans. And this is what we have come up with. If the former spouse dies before the employee, just generally, you have two options. One is to divide. So let me backtrack. There's a cost for the survivor annuity that comes off the top. And that cost can be allocated in different ways. So there are two options. One that generally people go with. One is that both parties basically share in the cost of the survivor annuity, and the other is that the former spouse pays for the cost. So generally, if the cost is divided between the parties, then the employee's paying something to get something in return. And so for that, the former spouse's share, generally the order would be written to have it revert to the employee. When the former spouse is paying for the entire cost of the survivor annuity, then generally the parties will agree that former spouse's share either go to the party's joint children or the former spouse's estate. Those are your limitations. You can't leave it to the next door neighbor. It has to go to the child of the participant or the estate. So those are the two options that we play with and talk about the costs and the allocation of costs. The presumption in most cases is that each party is paying for the possibility of receiving more than their respective marital share in the event of death. So this is gonna, you know what, I'll be able to show you more when I go into and actually show you the program. But with the survivor benefit even remaining the same for the former spouse, there's a portion of this community that is going to the former spouse. So likewise, if that occurs, then former spouse's share, if he or she dies first, would go back to the participant. The participant would basically get 100% of the pension. Then in that case, it gets more than the community property interest. So we play with those concepts, and this generally is what people will agree to, that the parties, they're going to prefer the possibility of receiving more funds when they're alive than leaving them to a beneficiary. So I know that, so just generally the parties will split the cost of the survivor annuity and have the reversion, if the non-member dies before the member, go back, so that non-member share goes back to the member. So what is the cost we're talking about? And by the way, it's taken directly out of the pension. So it's not like somebody's writing a check to pay for the cost every month. It's that they just deduct it from the pension. For CSRS, the cost is a little less expensive. It's 2.5% of the first 3,600, and then 10% of the remainder. And for FERS, the cost is 50% survivor benefit is 10% of the retirer's annual annuity.
Louise,
Yeah.
we have a question. You may have answered it because this was 5 minutes ago, but let me make sure we covered this. What if bifurcation granted and no orders regarding retirement other than all other issues are reserved? Is the non-federal employee now out of luck?
Well, first of all, the court, the judge is supposed to deal with the retirement benefits one way or another, either with a actual quadro or a provisional quadro, which is the FL 348 form, or with an interim quadro, which is drafted. It wouldn't even apply in this case. So technically the judge should not have allowed that bifurcation to occur until those issues were dealt with. So in a situation where that wasn't dealt with, I would suggest going back in and just filing the quadro, because they're divorced. You just need to get the domestic relations order done for the federal employee plan. So does that answer your question? Is the survivor, okay. Susan, I hope that answers your question. I would just go to court and get it filed, or if both parties sign, they can, you can just submit it to court. The judge will sign in.
Do you see the other question? Yes, she did say thank you. Susan did.
Okay, is the survivor, okay, go ahead, sorry, read it.
Is the survivor benefit always 50% of the retiree's annual annuity? Yes, that generally yes. So that's for the first plan. It's 55% is the maximum survivor annuity for the civil service retirement system. But if the member's already retired, they might have chosen a different value for the maximum for the survivor annuity. So it's not guaranteed. Once the member's retired, it is whatever it is, whatever the member elected for survivor benefit cost. So it won't be more than 50% or 55%, but it could be less in that fact pattern. So there was one other thing I was going to say, and I've forgotten on this topic of costs. Maybe it'll come to me. Okay. When is it?
this is a major disclaimer that I give when, you know, if it's not possible to award survivor benefits, these are generally situations when it comes up. For this plan, and this also applies for military, by the way, which is, I don't even know how they can justify not having gotten rid of it. But if the former spouse remarries before age 55 and was not married to the employee more than 30 years, then there is no survivor benefit payable to the former spouse, even if it's awarded in the co-op, even if the former spouse later divorces. There is no former spouse that is awarded, a former spouse survivor annuity that's awarded to the former spouse. And we'll get into this a little bit more. The first order rule, if the first court order dividing marital property, which is usually the divorce judgment, does not award survivor benefits, and then the employee retires or dies before the domestic relations order is done and approved by OPM, you will not get survivor benefits. That's why we say, again, many times to do them concurrently. Don't do the judgment without doing the divorce, the domestic relations order. File them at the same time, serve them at the same time on OPM. A certified court file, if let's say you get all the work done and the domestic relations order is not submitted and approved, awarding survivor benefit before the employee's death or retirement. I think you can remedy that some way, but it would be an uphill battle with OPM. And a little quick note on OPM, which is a federal government agency that some of you may have heard of, and you can talk to any federal employee. I'll occasionally, when I see my postal worker, I'll say, you know, we'll talk about OPM. They are hands down the most difficult administrative agency or entity to deal with. And they make mistakes and they don't care, and you have to appeal even if your order is clear. I mean, they are, all I'm saying is when you get one of these cases, just tell your client, copy any and everything that they send to OPM, document what they're doing, because they may need to, if they're having problems. And if they are having problems, the best remedy is actually to go to your member of Congress, because they have a tighter inside track to get action moving in the right direction for the out spouse and also for the employee. I mean, I'm not saying this to scare you guys. I'm just saying you to be aware. The remedy is to go to your member of Congress, because they have the direct access, because OPM is very difficult to deal with and get through. They are getting a little better, and I don't know, I would say 8 out of 10 quadros we send, maybe even 9 out of 10, no problems, but they are very difficult, and it's good to be aware of that. And that's one more reason to have everything filed at the same time, so there are no potential issues that, and actually in my court orders, we have written the issue of the remarriage, so that not only do we let the parties know, but we have it in the actual court order, so they read it, they'll see it, because if they can wait till year 56, it might be a good idea if the former spouse can hold off getting remarried. So this is the first order rule. And they actually call it the first order rule, that if the participant retires or dies before a DRO is filed, that clearly awards the former spouse survivor annuity, it will likely, it will likely not be possible to award survivor benefits, to obtain survivor benefits, because the first order, which is generally the judgment, if it doesn't mention survivor benefits, that's the first order, and the participant retires and dies, you're not going to be able to get survivor benefits. You'll be able to get payments monthly until the participant dies, but you won't be able to get survivor benefits. And there's actually a regulation that says you can't go back new pro tunc to perfect the judgment to provide for survivor benefits. In the period between the time the participant retires and or not before the participant retires, but between the time of divorce and participant's retirement, as long as participant doesn't die, you can get a co-op, a domestic relations order done, even if the judgment doesn't award survivor benefits, and be able to perfect the former spouse's interest in that situation. So there is the ability to fix the matter as long as the participant's alive and not retired. So just some general information on OPM, called court order closed susceptible for processing. These are the minor differences, is actually the cost and the amount for the former spouse or survivor annuity if you're married. If you're not, it's called the former spouse survivor annuity. Extremely difficult. I'm just telling you things I already told you. And the good thing with OPM, unlike military, is you can name multiple spouses. So if the former spouse is getting his or her share, and then the participant remarries later, that second spouse or subsequent spouse can also get a survivor annuity. And the last point on defined benefit plan, the federal, is health insurance. We don't get involved with health insurance, but it comes up, the question comes up all the time. OPM on their website has a whole section just for former employees, former spouses to deal with health insurance. But the most important thing to know is once the judgment's entered, the clock is ticking to get the proper paperwork done to get the health insurance for the former spouse. And the only way that the former spouse will get health insurance, which he or she will pay for, but is really great insurance for the life of the former spouse, is to have an award in the domestic relations order for payment during the participant's life and for payment after the participant dies. So for a survivor annuity, even if it's $1, that's okay. So what happens sometimes, parties agree, we want to make sure the former spouse will get survivor annuity, but 100% of the pension will go to the member during the life of the participant. That's okay, but you've got to award $1 to the former spouse in order to preserve the ability for the former spouse to get life insurance or health insurance during the life of the member. Otherwise, he or she won't be able to get it. So they have really actually good information on the OPM website on this, and forms that have to be completed depending on when the member's retired or not. You would send it to the agency versus OPM. I would say, again, have your client copy, save any, and take notes on any relationship, anybody they talk to ensure that the health insurance is done, completed. I'll never forget one case. We did everything perfectly. And it was 2 years after, or 3 years, the woman called in a panic. She said, I got a letter saying they're going to discontinue coverage. Well, there's a thing called temporary coverage, which lasts 3 years. And then you convert, or you, at some point at a time, you've got to convert to the permanent health insurance. She did all that. She completed all the forms. She had saved and documented everything, but the agency that she sent it to, which she was supposed to send to, never forwarded it on to OPM. So at the 9th, the 12th hour, 11th hour, however you say it, the member of Congress got it through. I got back in the case and helped her on that. And magically they said, oh, we made a mistake, sorry, and you'll have continued insurance coverage. But if she didn't have that documentation, I don't know if we could have pulled that off, or that the member of Congress could have helped her. All right, so now we're going to talk about the thrift savings plan, and I'm going to continue doing the prompts, but Miss Lorena Duffy is going to take over and talk a little bit about that. So
thank you, Louise. So thrift savings plan is a defined contribution plan. If the employee has a pension plan, they have a thrift savings plan. Similar to other private defined contribution plans. One of the most significant issues is separate property interest. Did the participant contribute to the plan prior to date of marriage? Did the participant roll over separate property monies into the plan during the marriage, but it's composed of either 100% separate property or a combination of separate and community? Or is the earliest division date under the plan after the marital division date? And this doesn't really happen that often with their savings plan, but something to take into account. So for thrift savings plans, they are divided similar to all other defined contribution plans, which is an amount or a percentage, either as of a marital division date or whatever date the parties determine, a date certain, or as of date of account segregation, either an amount or a percentage. However, there's a fifth option that most private defined contribution plans that's not available with those type of plans, is that they will calculate the community property interest between the two dates of date of marriage and date of separation, which is super helpful if there's a separate property interest. But the caveat there is that they're gonna take the balance from date of marriage and subtract it from the balance at date of separation. So it's not actually a sort of equitable division of the plan, because the earnings and losses that should be allocated to the separate property interest, so whatever the balance was at date of marriage, plus any investment earnings on that balance would be considered separate property. This plan won't do that extra effort of calculation. It's just going to be, subtracting the two balances. And the result is that the member will be waiving a portion of the investment earnings and losses on their separate property interest. And the parties in the case will have to determine whether or not that's something that they want to do. If there's not a significant separate premarital separate property interest, it's not that big of a deal. If it is, then maybe they want to divide it a little bit differently to take into account those investment earnings and losses.
Now, I'm just going to show this back to this screen. These 5 choices, I'm pointing to the screen right now. These 5 choices, that's the language that should be in your judgment. Okay. Because that's what we need. If you just say in your judgment 50% of the community interest and there's a separate property interest, that's an issue that has to be dealt with post-judgment. And this happens with all defined contribution plans. We've done talks on this and we'll continue to do talks on this issue. But if the one thing we can get across on defined contribution plans is deal with that issue before judgment, because the parties, when they come to us, they're not happy that we have to reopen the case and basically start dealing with these issues of separate property, premarital interest. That's the most common issue. And Lorena, do you want to talk about the earnings or losses for TSP?
Yes. The next slide.
It's actually, I put it on the bottom of this one.
Oh, yes, sorry.
Yeah.
And also, it's just, I was looking at the time, Louise, we have 15 minutes, so definitely want to move forward to the platform. So I'm going to breeze by really quickly because we definitely want to see, we want you guys to see it, how easy it is to draft these orders on the platform. So when TSP is calculating investment earnings and losses, it's going to be based on the participants' investment choices at date of division, meaning it's not going to take into account any historical changes and investments throughout the life of that account with the plan. So again, as Louise said at the beginning of the hour, there's no perfect way to divide retirement plans. And this is one of the examples. It's going to be based on whatever the investment choices are at date of division. That's how they're going to calculate investment earnings and losses from the division date till the account is segregated.
Right. So these are
we always cover this. If you make your judgment clear, if investment earnings or losses are included, just say it. If they are included, include what day they start to accrue. Is it your date of separation, date of judgment, date of valuation, whatever date it is, pick a date. That's the most important thing. And I think, and also, as always, we have a calculation suite. This is where I spend the majority of my time when I use the platform. This is amazing. If you haven't used it, please use it. You can calculate investment earnings if you you don't have records or whatever it may be. You can use the different calculators to calculate the community and separate property components of the defined contribution plan of the TSP. You could divide it with the time rule. It's all there for you. I'm gonna leave it back. We have 13 minutes.
Okay, yeah, this is where we're going to go to this screen. I'm just going to go through judgment language, super important. These are the common problems. Most of them is a missing plan, very common, or an award that isn't possible to allocate it to that particular plan. The most important thing you can do is in your judgment, if survivor benefits are supposed to be awarded, write it in the judgment. Our Quadro Council has very specific judgment language for federal employees, which a lot of people use. And that has a whole section on survivor benefits, but that's the most important thing. Also, we have great contact support, which people are using all the time. And I'm going to finish this and then go to the PowerPoint, but start thinking about this at the beginning of the case, not the end. And then you'll be able to withdraw in peace if you have judgment language and both the orders are prepared and filed at all at the same time. So now we're going to go, we're really trying to change behavior and why we keep doing these things and talks into education, trying to get information out to people and we really appreciate your time and listening to us so that the Quadros can facilitate what's written in the judgment and everything's done properly. And we have a free trial going on, which Carlton and Araceli will tell you at the end of the program. So we definitely want you to know about that. But I want to take a moment to just show you the dashboard and go through really quickly. So this is where you kind of live and breathe and can find information on private plans, public plans. There's so much information on here. But if you wanted to divide a FERS plan, and especially if you are in agreement with what the majority of people are, you just click, and I'm just going to take you through this real fast so you can see how easy it is. Honestly, if you're a subscriber and you're nervous about it, even after you've done it and you want to have us check it, we're happy to do that because we know until you get comfortable with the software, I'm just going to go with Los Angeles, that's where we are. You can go for the county, central districts, downtown. So this information, this is stuff your staff can use if there's information in the questionnaires that 2000 that we have on the platform that will help. That if you follow the questionnaires, everything that's in the questionnaire is a question that will be asked on the platform. So if you get that information, you'll be able to complete this. This information that you generally will get in a case regardless. So there's the first screen. The most important thing is the participant active or retired. So we're going to choose active just for the sample. Is there a survivor benefit to be awarded? We're going to say yes. And then we go through these questions that deal with the law, if it's even possible to award the survivor benefit if the AP is remarried. No, is the AP remarried before age 55? You say no. Is this a legal separation? Because that will be drafted differently. We'll say no. So those are the most important provisional questions. And then you just fill in the information on I did this on Homer Simpson. So I'm just going to show you this screen, and then there's one more screen you just put in your email address. So you just fill out basic information, and then what will be emailed to you immediately is the actual Quadro. So here is the deliverable packet that comes to you in an email. What we have is an explanation memo that you can show your client. It also helps you understand exactly how it was divided. and the implications. If it's something that the parties don't agree with, then you can tweak it, and certainly contact us for support on that, because we wouldn't want you to do something that isn't allowable under this particular plan. But I think these explanation memos are really helpful. They're also helpful if you have to go to court on the matter, and then the judge could understand what's in the order, because they generally don't like to read the orders. So here's the actual order. And then I'll just show you a picture. I'm not going to go through the whole thing. This spells out the time rule formula that should be entered. And this is where the cost is paid 50-50. So that's, I'm not going to go through the whole order, but you get the idea of how easy this is to do. So we're going to go back to, oops, I don't know what that is. Okay. Sorry. Okay. Is that me? Oh my God, I'm so sorry.
Okay.
It's spam. Oh my God. All right. So now we're going to go back to the member dashboard, back to federal plan. So then you want to do the TSP. The same thing where you have the questions, you go through the state information. We'll get there. Let's do Fresno, this one, then you go county. So just going to get you to the main screen here. 2000, no, 10. So what's great is if you do the free trial, you could just fool around with all this and really get a sense of whether it's something you would want, or just it's just to know it's out there. It might be something that's helpful for you. But these are basically the 5 options that we went through. There's additional information here and tips, but let's say you choose option 1, there's no separate property premarital. That's gonna, and they're gonna divide as of the default date, which is the date of separation that was inputted previously. The award's 50%. The loans, if there are any loans on the account, we would generally default to excluding them. We can spend more time talking about what that means, but basically it divides the community interest and the loan between the parties when you exclude the loan. We've done some talks on that. We're happy to do it again, but I can't spend time going back on that, because I know it's kind of hard for people to wrap their brain around it. So then you go through the same prompts, same party information, and then you're emailed the packet. And this is the packet that's emailed to you. A same explanation memo that tells you everything that is generally in the quadro that's of most important to the parties. And then we have the actual award is here. But as you can see, the language is different because the plan wants certain language. Depending on the different plan, they want different language. That's why there is no one size fits all quadros. And that's the general. I just wanted to make sure you could see for federal employees how easy it is to get the work done. We also have in our case management tool information from discovery to judgment on what you would need. We have questionnaires that for federal plans, if they're dealing with a federal plan, we have them for every type of plan. So these are fillable forms that when you get the case, you can go through this with your client or email it to them. They can let you know more information. And what people like, and I know it's just interesting, I had a comment recently on from somebody who just wanted some general information. They had a company coming in for a federal employee, and they told me how grateful they were to be able to read just generally information on what these plans are all about. And the whole point of Quadro Council is to be able to give divorce professionals access to information that's case specific and plan specific in an easy way. because otherwise you're not going to do it because you don't have time and nobody's going to pay you to do it. So this is, I've been doing this for so long, and it's this whole company and everybody behind it. We see these issues and the problems, and we want to make a difference in the divorce community and the divorce world, because this is a systemic problem that's going on nationally, and we want to change it. So that's our talk. Lorena, do you have anything you want to add? I crammed a lot in there at the last minute. I don't know.
Anything, Lorena? No?
No, I just answered a question. I thought just in the last few minutes, he said, how many quadros do you need if you have one DB plan and one DC plan for a federal employee, and you need one for each? You cannot consolidate them. So one domestic relations order for each plan. Another thing to take into account is sometimes employees have both a civilian account, which their savings plan, and a military account, things like that. I don't know if we want to say anything on that, Louise. I just thought about it right now.
Yeah. I mean, you would, we have, so we're just covering federal employees. So we do the defined contribution plan for federal employees. But if you have a military case, which we're going to start doing military talk, stay tuned. It's exciting. And you can do a military thrift savings plan here and a defined benefit plan for military here. So, and there are forms that have to be completed. So I'm really excited to show everybody the military plans. I think we'll start sending those out to do talks on those in January and onward with the Quadro Council, and also with different bar associations.
Louise, I have a question, because I learned this yesterday. In the military, are you saying that you can do 2-in-1 quadros with the military? Because I know there's a few plans that you can do it, but it's very few.
It's very few. And I would say, and not for military, not for any public plans. There are a few private ERISA plans that, and they're the entertainment plans, honestly. They're the Directors Guild. But almost all of them you would do separately, except for very few where they prefer to have one quadro for both plans.
Okay, we're going to start losing people now because it's on the hour. We're at 2 o'clock. I want to reiterate that Louise had mentioned that we are offering the 30-day free trial. And we've learned from this experience too with, I see some names that we've participated with, where if you actually have a case, sign up for the free trial. We'll onboard and train you using your benefits division case as the example, and generate it at no cost for you. If you would like to contact us, you can go to quadrocouncil.com and you'll see all of our contact information and how to get a hold of us for the trial or any other questions you may have, or if you'd like a presentation. We do have one more Zoom webinar coming up this year in the memorable year of 2020, which will be the third Friday in December, December 18th. All of you should be getting an email and registration form in the next couple of weeks. I want to thank you all for joining us today and wish you all a happy Thanksgiving week. Thank you.
Yeah.
Thank you.
Bye, everybody. Hope to see you live someday. Right? Oh my God. Right? I think we're all feeling that way. All right. Happy Thanksgiving.
Thank you. Bye.